Everyone's so obedient this morning. It's fantastic. So I'd just like to welcome everyone to the Westray Plus 20 event. I'm Andrea Peard. I'm the National Representative of Health, Safety, Environment with the Canadian Labour Congress. Obviously, welcome everyone. I'd just like to make a couple of announcements to begin. All the procedural stuff. So first of all, the washrooms. So there's actually two sets of washrooms. The first, if you walk out this door and keep going straight past the foyer, you'll go through 3 sets of double doors, and the washrooms are on your right. About equidistant, if you walk into the foyer and go down the stairs 1 level, the washrooms are on your left. Emergency exits are, if you walk out the door, on your left through the big doors to the outdoors. I also wanted to make an announcement. Obviously, there's a camera in the middle of the room. We are being live streamed today and recorded. So we invite people throughout the day to ask questions. The sessions, for the most part, will be participatory, and there'll be a question and answer session afterwards. So if you do ask a question, please know that you will be recorded, but only orally. So as you can see, the camera is just pointing at the stage. And so if you ask a question, your beautiful face will not be in the camera, but your voice will be heard. And for those of you who are watching via live stream, please know that you can also ask a question. Simply email the email account that's listed on the webpage. You can contact us as well via Twitter, but I think that email would probably be best. And we'll ensure that someone here live asks your question, either in French or English. And 2 more announcements. Today will be a bilingual event. On va parler en français puis en anglais. Donc, si
you don't understand English or French, it's time to go and look for a headset.
Please, it's very important to have your translation device and your écouteur ready throughout the day, because people will be switching from French to English. And most importantly, we will be keeping to time today. We have a lot of fantastic speakers, and we want to make sure that we have enough time for all of the sessions for people to ask questions. So we will be quite firm on time, so please be conscious of that. So all that being said, I'd like to introduce Catherine Lapel, and it's really an honor to do so. Catherine is a friend and colleague, and is just generally an impressive and fantastic person. She's currently a full professor of law of the Faculty of Law, Civil Law section at the University of Ottawa, and holds the Canada Research Chair in Occupational Health and Safety Law. Catherine is also Associate Professor of Law at the Université du Québec à Montréal, where she was a professor from 1982 to 2006, and where she is a member of the Interdisciplinary Research Center on Biology, Health, Society, and Environment. Catherine is an adjunct professor at Carleton University School of Social Work and an adjunct scientist for the Institute of Work and Health. She specializes in legal issues relating to occupational health and safety and to workers' compensation, and is the author of numerous articles and books in the field. Now is where I'm going to check if everyone has their devices. Titulaire de la chaire de recherche.
She is the Canada Research Chair in Occupational Health and Safety Law. She joined the University of Iowa in 2006. She's a member of the bar since 2008. She was a professor of law at the legal sciences at the University of Quebec in Montreal from 1992 to 2006. She's member of the Interdisciplinary Research Group on Biology at the University of Quebec in Montreal. She is specialized in issues related to law, occupational health and safety, and she's belonged to a number of union organizations, primarily in the framework of the invisible crimes that hurt people.
People can hear me. Est-ce que ça va? Je vais présenter en français.
I'll be making my presentation in French, primarily because Steve Biddle, my colleague, will only be speaking in English. So,
premièrement, au nom du...
First of all, on the name of the organizing committee and the research chair, I would like to warmly welcome you here, and I thank you for being here. I'd like to say a few things about how all this got started, and just to give you some suggestions so that you can better analyze and understand what we'll be hearing over the next 2 days. The activity for today was organized to commemorate the mining disaster in Winstray in 1992. And the activity invites academics from Canada or from elsewhere, and also union and management and people who work with the police, the Crown prosecutors, and professors from different faculties and disciplines. The idea of organizing this activity to commemorate the 20th anniversary of the Westray disaster has come primarily from the union movement, but it was also an initiative from a young researcher, Corey Willard, who was a student in common law and did her work on the Westray disaster and said something had to be done. I think that's particularly important. And we can applaud Chloe. Now she's really going to be embarrassed. And it was a pleasure to respond to her initiative, and I think it's important for an organizing team. The team that organizes this symposium is organized by Professor Stephen Biddle. He's a professor in criminology, and he's the primary researcher and organizer. There's Professor Hilaire from common law. I work in civil law. There's also the participation of Andrea Perk from the CTC, the CLC that you just met, Andy King, someone from the steelworkers. He's a master's student at the University of Ottawa, but he's also a key player in this legislation at that time. And it's someone who worked with the steelworkers for a number of years, and most of you know him. There's also Corey. He's on the organizing committee. We benefit from extraordinary support from Caroline Couillard, who's the coordinator of this activity. And most of you had an opportunity to meet her, even if it was just by email, from the very beginning of the organizing of this event. We would also like to emphasize the support from SSHRC and the two faculties, social sciences, and also the common law and the civil law faculties. And something that I'd like to underline is that you've all been invited here as participants in a panel or speakers, or as you're a member of the public. You've all been invited individually, but people will be speaking. They're not going to be speaking on the name on behalf of their organizations. They have to be able to speak without being accused of the behavior of the police or of a Crown prosecutor or union or management or whatever. And we hope that we will have frank sharing experience without accusing anyone. One of the objectives of the activity is to provide a place where we can share freely, and so that we can collectively better understand what I would say personally is the stagnation in the implementation of criminal law responsibility. And we have to leave our institutional hats at the door. We're not here to judge, but to work together to strengthen criminal liability. If you have any questions on the scientific or legal context, there are lots of lawyers and non-lawyers in the room. I don't want to create post-traumatic stress by saying that there are a number of speakers who are legal experts. Whether or not you're lawyers, you'll be hearing from Australia, the United Kingdom, France, and Canada. The law from one country to another is very different. Whether you're an activist or a jurist, it's very important to understand that, because activism afterwards is a result of the reality that these people are describing. To answer the question concerning the impact of criminal legislation on the practices of corporations and other actors, to know if corporations have changed their behavior because this criminal law exists, we have to look at the legal framework that exists here. I'll give you a few questions that will help you to think about this in the presentations that will be coming up. First of all, who are the people who would potentially be targeted by criminal law? The answer in Canada is different from the one in Australia, is that the members of health and safety committees can be what happens with shareholders, what options are available for Crown prosecutors outside of criminal law. Are there laws for health, occupational health and safety that would allow a player who was negligent to be taken to be imprisoned? What role is there for the police, and is there adequate training to allow them to investigate crimes that happen when there is a workplace accident? And something that's very striking for people who work in common law in Canada, Anita Bomani and François Lafort going to be in a video conference from France now, and they say what role is for the victims is in this penal process. Things are very different in Europe, and we wonder whether this is going to make a change or not. These are some of the questions that you can use when you hear this. First of all, I will present Stephen Biddle.
In the Department of Criminology, University of Ottawa. His main research interests are in corporate crime and regulation. He's the author of a book that has just come out and that I strongly recommend, Still Dying for a Living, Corporate Criminal Liability After the Westray Mine Disaster, published by UBC Press in 2012. And his current research, funded by SSHRC, by the Social Science and Humanities Research Council of Canada, explores the growing international interest in the development and enforcement of criminal laws dealing with serious injury and death in the workplace. So I leave the floor to Steve. Thank you.
Good morning, everybody. Thank you, Catherine, for your introduction, and to everyone for being here today for what I'm sure will be a very interesting day and a half of discussion and debate about the growing interest in corporate criminal liability. I want to echo Catherine's comments in thanking the co-sponsors of this event, as well as my colleagues on the organizing committee for their efforts in bringing this symposium to its fruition. In particular, I want to thank Carolyn Couillard, conference coordinator extraordinaire, for all of her hard work in organizing this event. I think quite simply, without Carolyn, we wouldn't be here today. I also think that it's important for us to acknowledge the 26 men who were killed more than 2 decades ago in an extremely preventable disaster caused by unsafe and illegal working conditions. It is in their memory that we're here today to examine the importance of corporate criminal liability and explore ways of making workplaces safer so that hopefully workers can stop dying for a living. What I would like to do this morning is provide a brief overview of the Westray Bill's development, and in doing so, I hope to shed light on some of the reasons we're here today. To understand why, despite expectations that the Westray Bill would fundamentally transform corporate criminal liability and help crack down on corporate criminals, the law has fallen into a state of virtual disuse. Each year, close to 1,000 Canadians are killed on the job or die from work-related illnesses, while thousands more suffer debilitating injuries. Despite the frequency and seriousness of these incidences, they face little public, political, and academic scrutiny and are rarely treated as crimes worthy of criminal justice intervention. Defined away as unfortunate accidents, the regrettable but largely unavoidable risks that go along with the pursuit of profits, injury and death in the workplace is an invisible crime. Crime is about the perils of guns, gangs, and drugs, or so we are told, not about the harms we experience while trying to earn a living. Given the low priority accorded to workplace injury and death, it was thus significant when, in March 2004, the Canadian government introduced criminal code legislation aimed at strengthening corporate criminal liability. Bill C-45, an act to amend the criminal code, criminal liability of organizations, most commonly referred to as the Westray Bill, introduced a duty for all persons directing work to take reasonable steps to ensure the safety of workers and the public, attributed criminal liability to an organization if a senior officer knew or ought to have known about the offense, and introduced sentencing provisions specifically for the organizational setting. As many here today will know, the Westray Bill has its roots in the Westray disaster and the subsequent public inquiry launched by the provincial government in Nova Scotia to investigate how and why the miners died. Chaired by Justice Peter Richard, the inquiry's final report, The Westray Story, A Predictable Path to Disaster, which was released in 1997, characterized the tragedy as foreseeable and preventable, unearthing evidence that the mines management had been warned over 50 times prior to the explosion about workplace health and safety violations, all of which were ignored. Justice Richard's report contained 74 recommendations aimed at preventing similar incidents and improving health and safety in the workplace, including a recommendation that the federal government change the criminal code to make corporate officials, quote, properly accountable for workplace safety. This recommendation was, in part, a reflection of the growing outrage over the fact that the mine's owners, Curragh Resources, and its CEO, Clifford Frame, were never held to legal account for what happened at Westray. Here, I think it's important for us to acknowledge the dogged determination of the United Steelworkers who campaigned extensively for Justice Richard to recommend changes to the criminal code, as well as their subsequent lobbying efforts at the federal level to put and keep the Westray Bill on the legislative agenda. I don't think it's overstating things to suggest that without the efforts of the steelworkers, along with those of the Westray Families Group, that the Westray Bill might have never seen the light of day. In introducing the Westray Bill, the federal government declared that it was an important step toward ensuring the accountability of organizations for the actions taken by their representatives. Pundits predicted that it would revolutionize corporate criminal liability, ending the lenient treatment of corporations through the introduction of stricter penalties and improved enforcement tools. However, peeling back the veneer of this so-called crackdown on corporate crime reveals a much different picture. To start, the law's introduction was anything but expeditious, subject to a 6-year-long process in Canada's Parliament during which questions were raised about the need for law reform. In addition, as I've already mentioned, since the law took effect in 2004, there have only been a handful of convictions and only a handful of charges, and one conviction and one guilty plea. Not exactly a revolution in corporate criminal liability. What is more, all of the charges laid thus far involve small companies where there's little difficulty tracing the chain of responsibility throughout the organization. Hardly the sort of large, complex corporations that critics had in mind when arguing for changes to the law. So how did this happen? How do we get to the point at which a law that was introduced to deal with serious corporate crime has been so rarely enforced? Well, in many respects, that's what we're here to discuss over the next day and a half. With the time that I have remaining, I would like to suggest that we can begin to understand the challenges of enforcing the Westray Bill by looking at its development, the process in Canada's Parliament leading to its introduction. My own research in this area examined the history of the Westray Bill, beginning with the Westray Inquiry Report's recommendation to amend the criminal code through the parliamentary process that brought the legislation to fruition, including the work of the House of Commons Standing Committee on Justice and Human Rights, an all-party committee that was tasked by Parliament in the spring of 2002 to study issues of corporate criminal liability. As part of my research, I examined parliamentary transcripts in relation to the Westray Bill, including the testimony of more than 30 witnesses, legal experts, union labor representatives, academics, family members of victims of corporate crime, who appeared before the members of Parliament on the Justice Committee, and I also interviewed those with knowledge of the law's development. Overall, I found there to be very contradictory messages when it came to the Westray Bill's development. On one hand, there is widespread support in Canada's Parliament for introducing new legislation that would hold corporations accountable for seriously injuring or killing workers and/or members of the public. On the other hand, however, there was significant reference and deference to various considerations that mitigated the seriousness of health and safety crimes and limited the nature and scope of corporate criminal liability legislation. These were the yes, it's a good idea, but statements that isolated occupational health and safety crimes from what's considered real crime. And I would like to highlight 3 sets of discourses, or what I refer to as knowledge claims, that I believe shaped, did not determine, but shaped the development of the Westray Bill: legal, economic, and cultural discourses. So first, what we see is that throughout the parliamentary process leading to the Westray Bill's introduction, law was treated as a specialized form of knowledge with unique rules and parameters. Those who attempted to speak to issues of law before the Justice Committee were subject to its traditions and methods and were expected to adhere to these qualities to be recognized as authorized and credible voices. In many respects, it seems obvious to suggest that legal considerations dominated a process that was expressly charged with examining options for law reform. Of course, legal discourse dominated. However, it's not just that legal considerations took precedence, but that in doing so, they authorized certain people to speak or certain ideas to be expressed, while those that did not follow the law's traditions were largely dismissed. The most prominent way that legal discourses dominated the reform process was through reference to traditional notions of mens rea. To be considered credible and feasible, any reform option that was given serious consideration could not be seen as straying too far from the idea that you needed a guilty mind to hold a corporation to legal account. It meant that legislators had a difficult time conceptualizing how to hold senior corporate executives, and hence the corporation itself, responsible for something they did not do, for something they ought to have known. For example, we can take a comment from an MP during the Justice Committee hearings where, quote, "How far up the chain do we attach accountability and liability? Some folks said that the directors should be responsible for virtually everything done by their employees. If you're talking about a large corporation that may have directors in Vancouver and something happens at a plant in Toronto, how liable is the director in Vancouver for what happens in Toronto? That's what I'm struggling with," end quote. So dominant notions of individual responsibility meant 3 things basically for the Westray Bill. Again, first, that only certain credible voices, primarily lawyers and legal experts, were allowed to speak to issues of law before the Justice Committee. This meant that alternative voices that spoke to structural causes of workplace safety violations, such as issues relating to the pressures of profitability or the very structure of the limited liability corporation, were marginalized. Secondly, progressive or alternative models of corporate criminal liability were dismissed as being too far or straying too far from established parameters of individual guilt. The best example of this is the New Democratic Party's proposed corporate culture model, which is based on Australian legislation that was seen as too vague and imprecise. This does not mean that the Australian model of corporate criminal liability would have been the better option, and we'll hear more about this law today in Professor Johnston's presentation. But as an alternative model of corporate criminal liability, it was quickly discounted. Third, as a result of the dominance of traditional notions of mens rea, some observers have suggested that corporate executives and board members are no more at risk of facing criminal responsibility today than before the Westray Bill was introduced. The Westray Bill reform process was also animated by a healthy respect for neoliberal economic principles. Legislators frequently referred to the importance of corporate capitalism and that any attempts to hold corporations and corporate actors to legal account should therefore not be too punitive. They believed that an overly stringent law would mean that corporations would no longer be able to attract the best and brightest as board members, referred to as director chill throughout the Justice Committee hearings, or that corporations would simply pack up and leave the country if the law was too strict. So, for example, as one MP suggested, and another quote, "You have to be very careful if you believe all these Canadian corporations and companies are just going to stay around if we put something that's a little too tough on them. I can tell you there are many companies right now who look at our tax laws and other laws and are on the verge of heading somewhere else," end quote. So this statement reflected an overall desire to protect neoliberal economic principles and the corporation's role therein, not exactly conducive to getting tough on corporate crime. And I think that this commitment to neoliberal economic principles is particularly germane today as governments at all levels enthusiastically embrace austerity measures and, as part of this, virtually bend over backwards trying to create business-friendly environments. Indeed, the state's response to the current economic crisis raises important questions about its ability and desire to hold corporations to account for their serious wrongdoing. Neoliberal principles, particularly the idea that as individuals we are all responsible for our own roles in the so-called free market, were also front and center when it came time to contemplate who is responsible for workplace safety. Workplace safety crimes were repeatedly conceptualized as the responsibility of workers, labor, and unions, as much as, and even at times more than, management and executives. Workplace accidents most often were seen as a result of defective, low-level employees, not bad corporate management, malign corporate culture, or profit-maximizing strategies. And there's a particularly telling example of this commitment to individualized notions of responsibility during the Justice Committee hearings when a committee member from the then Canadian Alliance Party questioned a former Westray mine worker, Vern Thoreau, who will be speaking at tonight's reception, who was testifying about his experiences working at the mine. Following Mr. Thoreau's presentation, the MP asked him whether the workers themselves were not responsible for the disaster, for not taking steps to ensure that the explosion did not happen, or by refusing to work in unsafe conditions. Despite the overwhelming evidence from the Westray inquiry that mine management and owners refused to take safety seriously, that they put production and the pursuit of profit before worker safety, and that they bullied and disciplined workers who complained about unsafe conditions, the belief prevailed that workers are responsible for their own safety. Finally, looking at the Westray Bill's reform process, we find frequent references to historical, culturally based beliefs that corporations and corporate actors are not criminals. Dominant voices argued that even if some corporations occasionally do bad things, they cannot be painted with the same brush as common criminals. From this perspective, crime and its control is deemed to be about the street-level violence that strikes fear in everyone, not about corporations who routinely cause injury and death. In many respects, these dominant notions of crime have animated the Westray Bill after its enactment. First, as I'm sure will be discussed today, the Westray Bill is not on the radar of most police and prosecutors. In dominant cultural terms, it's not seen as the real stuff of cops and robbers. Second, immediately following the Westray Bill's enactment, the most significant development was not its enforcement, but the emergence of 4-fee services offered to corporations on the measures needed to avoid criminal responsibility. These measures included various training courses and seminars that detailed the law's parameters, how to avoid getting caught, and what to do in the event of serious injury and death in the workplace. What is most interesting, however, is that these programs and services are dominated by the language of due diligence. Due diligence is a discourse of risk management, not of eliminating risk. Instead of preventing bodily harm, the goal is to reduce it to the extent possible and defend against criminal charges in the event that such harms do occur. The overriding concern is avoiding criminal responsibility, not with implementing an ethic of safety or ensuring that nobody is killed at work no matter the circumstance. As Eric Tucker has observed in noting the professional risk managers that have sprung up in response to the Westray Bill, while some companies may improve their safety practices as a result of this training, quote, they may also adopt legal strategies such as invoking their right to counsel and their right to remain silent in the aftermath of a workplace death or serious injury that do nothing to reduce worker risk exposure. In this respect, as Courtney Davis suggests, risk assessment can easily become paper exercises that are more about insulating an organization from legal responsibility than seriously improving workplace safety. So what does all of this mean? Well, in many ways, the assumptions that animated the Westray Bill and the meanings inscribed in its provisions throw doubt on its ability to hold corporations legally accountable for their harmful acts. However, and this is the important part, it would be wrong to conclude from this that the Westray Bill's fate was predetermined or its future complete. The Westray Bill is a new and symbolically important way to speak about corporate wrongdoing and a reflection of the growing concern with the dangers of corporate power in the absence of accountability. Its introduction reminds us that the exercise of corporate power and influence is always changing and never absolute, and the state does not automatically act at the behest of corporate interests. The fact that the Criminal Code of Canada now contains specific corporate crime provisions means that some corporations and corporate actors have been and will be held to account for their harmful and illegal acts. In this respect, the Westray Bill creates the possibility for change, an important foundation for struggles to ensure workers' safety. And this symposium represents a unique opportunity for us to explore this very possibility. Thank you. So now I get to change hats and introduce our next speaker. And our next presenter is Professor Steve Toombs, whose presentation is entitled Still Killing with Impunity, the Political Economy of Corporate Criminal Law Reform in the UK. And Professor Toombs is going to provide us with some insights regarding the introduction of corporate manslaughter and corporate homicide legislation in the UK, which is different than what the Westray Bill has attempted to accomplish here in Canada. Steve Toombs is Professor of Sociology at Liverpool John Moores University. He has a long-standing interest in the incidence, nature, and regulation of corporate crime, and in particular, the regulation and management and health and safety at work, and has published widely on these matters. Professor Toombs works closely with the hazards movement in the UK and was chair of the Centre for Corporate Accountability from 1999 to 2009. Please join me, and it's my pleasure to introduce in welcoming Professor Steve Toombs. And that's the wrong PowerPoint. Yeah.
Thank you. Okay. Thank you. Okay, thank you very much. Let me just start by saying thanks to all of those people who've made this possible and afforded me the privilege of inviting me to come here. So thanks very much for that. Can I also extend solidarity to the Westray Families Group on behalf of a similar, if you like, group with whom I work in the UK. Families Against Corporate Killers are families who are all bereaved by workplace fatalities and have asked me to express solidarity on their behalf to the Westray Families Group. My reference point today, as Steve has indicated, is of course with the UK equivalent of the Westray Bill, our own Corporate Manslaughter and Corporate Homicide Act. In a sense, I'm happy to talk about that act in the context of questions and discussions. In a sense, though, my interest and my concern in what I'm going to say to you is less with in fact, it's not at all really with the act itself, its provisions and so on and so forth. It's more with the context in which the act has been introduced and which has rendered it largely an irrelevance, I think. So just to give some very broad context about the state of occupational health and safety in the UK, if we look at the numbers of fatalities, we find the most recent figure, 2011-2012, provisional when I made these slides, but in fact the provisional figure of 173 has now been confirmed at 175 fatalities, acute injuries which lead to death in the workplace. But this is only, this figure recorded by the Health and Safety Executive is what I've come to call a headline figure. And I spent, very sadly, about 10 years, about 20 years ago, trying to reconstruct a more accurate fatality figure from official government statistics. So workplace fatalities are recorded by a whole series of different agencies. And one can reconstruct that figure to reach an actual recorded figure of about 1,400 to 1,500 deaths from fatal injury per annum in the UK related to work activities. And it's also been estimated, although I haven't made these estimations, but it's also been estimated, extrapolating from cardiovascular heart disease data and also from cancer data principally, that there are up to 50,000 deaths in the UK every year from fatal occupational disease. So work's still killing, of course. If we add to that the relentless toll of non-fatal injuries to workers and to members of the public, and also recognise that only about a third of those injuries are actually reported to the authorities. And it's also worth saying, in this brief statistical context, that rates and numbers of fatal and non-fatal injuries in the UK have risen slightly in the past 2 years, which is very odd because, of course, the UK, as many other economies, is in recession precisely at the time we'd expect those rates to decline somewhat. So, to say very, very briefly, in the UK, we had a first set of proposals in 1994. These were firmed up significantly in 1996 to introduce a new law to call companies to account for killing, corporate manslaughter and corporate homicide. That law took 13 years to reach the statute books. So we have the Corporate Manslaughter and Corporate Homicide Act of 2007, which in fact came into force on the 1st of April 2008. The Act applies to organisations, not specifically corporations, not simply for-profit entities. And I should also say it includes no individual liability, so it makes it possible to prosecute organisations but not individual directors. There have been 3 convictions thus far. The first one, the kind of landmark case, if you like, was against a very, very small company, Cotswold Geotechnical Holdings, just 8 employees. It was convicted, having contested the case, it was convicted of corporate manslaughter. It was fined £385,000. It appealed against the verdict. It lost the appeal, and within a few days went into bankruptcy. So the company no longer exists, and the fine, of course, was never paid. The 2 subsequent cases against slightly larger companies, but medium-sized enterprises really, not the large complex organisations who many thought would be the object of the law, of course. The 2 subsequent prosecutions neither of those were contested in court. The companies both pled guilty, and again, as you see from the judge's comments in the case of Lion Steel, the 3rd case there, the judge, in sentencing, measured the level of the fine against endangering the jobs of employees as very unsurprising kind of judgment to reach. So there have been just 3 cases so far, and the Attorney General, Dominic Grieve, was asked a question in the House of Commons earlier this year, in April 2012, was asked why there were so few convictions or why so few cases have gone to court. And Dominic Grieve's, and I'm not calling the guy a liar, right, but he is a Tory, but in any case, I mean, but Dominic Grieve's response was that there were about 50 cases under review, which is quite staggering. So I'd be very interested to see how many of those cases ever reach court. I have subsequently put in a Freedom of Information Act request for details of those 50 cases, but don't expect to hear much in response to that. So one very obvious question is, why have there only been 3 prosecutions? And there are some possible answers internal to the law themselves, but there are also issues about enforcement, I think, and I just want to mention a couple of reasons as to why there may have been only 3 prosecutions. The first is very simply the commencement of acts. So for a case to be taken to court and proven in court, all of the factors which contribute to the death or deaths had to have been put into place after the 1st of April 2008 when the law formally commenced. So if you think about the ways in which certainly large complex organisations, as they develop standard operating procedures, lines of accountability, make decisions and so on and so forth, if you think about how large organisations operate, one might expect that it will be sometime in the future before any of those would ever come into court in terms of all of the relevant factors having been put into place after April 2008 which contribute to the death. Following a workplace death in the UK, there's a formal procedure whereby the police and the Health and Safety Executive, the main health and safety regulator, under a protocol of liaison, they investigate jointly, but in fact the police take the lead in any investigations following workplace death until the police decide that there's no criminal case to be answered, and they will then hand over investigations to the HSE. Now, it's certainly the case that, as one legal commentator, Jonathan Grimes, has put it, it's certainly the case that part of the issue about there being so few prosecutions may simply be the modus operandi, the attitudes of the police themselves. As he says, the police are ill-suited to and ill-equipped for the challenge of investigating and prosecuting corporate manslaughter offences. Essentially, they lack health and safety experience. And of course, to echo what Steve said earlier on, the police also treat workplace deaths in general as something different from a real crime. So what comes out of the end of their investigations is less likely to be a case for prosecution. On the other hand, the HSE, the regulator in this area, of course, the HSE does have the expertise in dealing with occupational health and safety issues, obviously, and of course occupational fatalities in particular. But the HSE, when it approaches investigations, historically hasn't and still doesn't. It doesn't look for a prosecution. It doesn't look for a culprit. It doesn't look for a criminal. It looks for a cause. It looks for a cause of the death which may then be prevented in the future. And indeed, it's very commonly noted of the HSE in the UK, both by critics and supporters, The HSE as an organisation, and HSE inspectors in particular, view prosecution as a failure. Law is the last resort. They would much rather engage with the employer in order to remedy conditions in the future which generated a death than prosecute an employer. So the HSE kind of has the expertise, but the HSE doesn't have the mindset to prosecute. So there are clearly factors about the regulatory bodies involved here. But more important, I think, I want to turn to say something about wider anti-regulatory political and economic contexts which have unfolded as the law was introduced. This tracking of HSE enforcement is something which I've been working on, or worked on with a colleague and friend of mine, Dave White, also from Liverpool. There are two universities in Liverpool. Dave works at the good one, I work at the bad one, right? But in any case, so this is joint work. What we found, and it's through a series of freedom of information requests, is during the first 10 years of the 2000s, under a Labour government, mind, right? This is under a Labour government, a significant decline in all forms of formal enforcement on the part of the HSE. So we're not talking about death specifically now, we're just talking about regulation on the part of HSE in general. I won't read the figures, you can see them for yourself, but significant declines in inspections, in investigations of major injuries. Major injuries are major injuries, so when we talk about major injury in the UK context, it's a blinding, an amputation of more than fingers or toes, a serious burn and so on. So less than 1 in 9 of major injuries are now even investigated by the HSE, which is quite a stunning statistic. Falls in the application of notices, falls in prosecutions. The only two indicators which did slightly increase were the average penalties on conviction under the Act, under the Health and Safety Work Act in general, and also following a fatality with prosecutions under the Health and Safety Work Act. So you can see that those average fines did increase slightly during that decade, but of course the levels, the absolute levels of fines are still incredibly low. So the Corporate Manslaughter and Corporate Homicide Act was brought in towards the end of a decade when health and safety regulation and enforcement in general had been undermined on almost any statistical criterion. But of course there's also another wider framework within which to consider the introduction and application of the Act, and that's something with which we're all far too familiar, which was the financial crisis began to unfold from the end of 2007 onwards, and then the recessions and the austerity which many major industrialised countries are experiencing, not least the UK. The UK government bailed out financial services industries to the tune of £850 billion in 2008. So the state intervened to rescue parts of the corporate sector, and the state's commitment, of course, is, in Andrew Gamble's terms, to create the conditions for a new expansion, to restore profitability, to restore employment, taxation, and so on and so forth. Now, I'm not going to talk, of course, about the cause of the financial crisis, and there are many, reams of books and articles that have been written on it, and I've had the misfortune to read many of them. Whatever one thinks about the cause of the financial crisis in that period, the level and nature of regulation is probably generally accepted as part of the story. Okay? Something was happening in terms of the way in which the financial services sector and the corporate sector in general was regulated, which generated the financial crisis. Given that fact, or given that kind of pretty much consensual agreement, it's incredible in the UK context that when we go into general election in 2010, all of the political parties were committed to the idea of deregulation. 2 years after the financial crisis, deregulation as an idea hasn't been undermined at all. Deregulation is seen as necessary and desirable. Regulation in general, of course, you'll be familiar with this kind of language, is seen as inherently burdensome, only to be an option of last resort. Regulation entailed costs for business and government. The government was experiencing a fiscal crisis, so of course couldn't expend those costs, therefore regulation became fiscally less likely. And of course, not of course, but the representation of the way out of the age of austerity was private capital. And if private capital was going to do what private capital is supposed to do, create jobs in its own terms, create jobs and taxation, of course, private capital couldn't be regulated. So you have the idea of an even freer corporation and a retrenched state as the only vehicles for economic recovery. How am I doing for time here? Sorry. I don't need 10, great. Alongside these very, I think, both material developments and also ideological developments, there was also there's also been, I should say, in 2010, the Labour government, which of course had undermined health and safety enforcement, lost the election, not for that reason, obviously, and a coalition government led by the Conservatives, but along with the Liberal Democrats assumed office. And obviously Cameron is the what do you call him, Prime Minister, head of the government, and the leader of the Conservative Party. There was a very explicit attempt, almost immediately after that election victory, or after the coalition was cobbled together more accurately, to create a new form of moral leadership. And actually, I think, I mean moral leadership in a very Gramscian sense, in a very, very explicitly Gramscian sense. Now, I could, and I have in other contexts, collected lots of these kind of quotations, which on one level are very funny, on one level are very laughable, on another level are very telling about the hatred, and I mean hatred, for health and safety regulation in particular, a governmental, and actually you might also say a class hatred for that regulation, on the part of a government which of course dreams of labour market deregulation in general, but certainly aspires to health and safety deregulation in particular. I've chosen two quotes to show you today, to bring to you today, both because not so much what they say is kind of typical, right? What Cameron says here is typical of what Cameron and his ministers have said on countless occasions. What's interesting about this quotation is that David Cameron made it in the context of his keynote speech in the wake of riots across, well, I was going to say the UK, actually mostly across England and a couple of Scottish cities. But a series of riots, London, Birmingham, Liverpool and other cities, Manchester, through the month of August. Cameron comes to make a speech and he starts talking about health and safety. It's quite incredible. Society's broken, he says, right? Of course, society's broken because it's riot-torn and unemployment levels are rising and so on and so forth. Society's broken, but because human rights always gets it in the neck as well, right, along with health and safety. But if at the end of this quotation, the human rights and health and safety culture are sources of damage to our social fabric, right? It's quite incredible, but very deliberately chosen language, I think. We have an obsession with health and safety that's eroded people's willingness to act according to common sense, right? We're so obsessed with health and safety that less than 1 in 9 major injuries even get investigated around this time, in any case. The second quotation I've also chosen, not because it's atypical, it's very typical, but I've chosen again for the place in which Cameron gave the speech from which this came. This is Cameron's keynote, keynote speech to his own party at the Conservative Party conference. So in many respects, the most important political speech that he makes in a year. And again, he wants to talk about health and safety. One of the biggest things holding people back is the shadow of health and safety, right? I mean, I thought it's joblessness, poverty, but it's health and safety, okay? One of the biggest things holding people back. And then he goes on to use some silly, vacuous example about controller substances, the COSH regs, controller substances, hazardous health regs, with the use of highlighters. Again, these things are always apocryphal, of course. But then, you know, he explicitly links in health and safety, the damage health and safety is causing, to British greatness, right? And here we have some imperialist echoes, right? Which one might expect. Britannia didn't rule the waves with armbands on, right? I'm not sure how familiar this is to you, but armbands are those things that you use to swim, right? Britannia didn't rule the waves with armbands on. At long last, common sense is coming back to our country because, at this point now, the government has launched an explicit deregulation program in the context of health and safety. And I'll just mention this very, very briefly. Within a few days in 2010 of the coalition being agreed, David Cameron dug up somebody called David Young, who I thought was dead, actually. David Young was Margaret Thatcher's favourite minister. Margaret Thatcher said of David Young, Lord Young, my other ministers bring me problems, David brings me solutions. And David had launched an attack which the unions fought off on health and safety in the mid-1980s. So I mean, when I genuinely did think that he was dead, his political career was certainly over, but Cameron brought him back. Cameron brought him back to review health and safety regulation. And of course we have, within a few months, a flagship report arguing for deregulation of health and safety. Within a year, then Cameron brings in an academic from a top London university to give some academic credence to the need for deregulation. And out of those two reports, the idea of low risk emerges. It's used loosely, flexibly, but the idea of low risk, of course, as a concept, is used to denote a whole series of workplaces which don't need inspection. That's how it comes to be used. And indeed, Business Secretary Vince Cable has just announced that in fact, a whole series of so-called low-risk businesses will now be exempt from health and safety inspection, which is quite incredible. And just to get a sense of what low-risk businesses are, the second paragraph there, that's all workplaces, all businesses in health, education, prisons and emergency services, public transport, buses, airports, postal services, agriculture, docks, electricity generation and light manufacturing. They all sound really safe places to work to me. Of course, they don't sound like safe places, and they're going to become more dangerous. So, to conclude, and I started talking about corporate manslaughter and corporate homicide, so I should come back to that very, very briefly, just to make clear that no large organisation, as I indicated, has yet been prosecuted. Amongst those 50 cases that the Attorney General says he has on his desk, there are two which relate to large public authorities. One is to a highways agency, Transport for London. The other is to a fire authority. So interestingly, it might be that it's a public body which is the first large organisation to be prosecuted under the Act. That said, the context I've been talking about has rendered the Act symbolically perhaps important. I agree with Steve on that, but has rendered it a material irrelevance in many respects. The HSE and the local authorities who enforce health and safety law across the UK have become virtually pretty impotent, virtually neutered. And private capital, compared to 10, 15 years ago, quite incredibly given what happened towards the end of the 2000s, is now much freer of regulation and is set to become freer from regulation. Thank you very much.
So that was fantastic. Thank you very, very much. So we do have time for some questions. So if anyone has a question or a point of discussion, particularly just listening to it, I found there were so many parallels between some of what we're seeing in Canada. So if anyone has a question, please raise your hand, hopefully high enough that I can see it. Sir, please.
Hi, Steve. My name's Kuzi Charamba from McGill University. Thanks for the great talk. My question, you're talking about deregulation as this post-2008 trend that we have, which is a problem, if you ask me. But even when we do have the law, there is still a problem with enforcement. And people tend to think that having law is always the solution to every problem that exists. But if we have the law and there's a problem with enforcement, then I think there's a problem with culture, really. Of getting people in the mindset of actually making use of the law that's there. Do you think culture is a problem? And if you do, how do you think we can get to changing the culture of actually enforcing whenever we have these situations of health and safety violations or whatever it may be? Thanks.
Thanks. I think that culture is a problem in this sense that, and again, I'm sure this will be familiar in your own context, which is that one of the ways in which the retreat from enforcement was justified through the 2000s by the Labour government was to talk in terms of society, you know, in many ways not dissimilar to the kind of language that Cameron was using, to talk in terms of society having become too risk averse, and a phrase which became very current, which was that health and safety had gone mad. So health and safety was somehow a pernicious culture which was affecting detrimentally many areas of life and preventing Britain from prospering. And that discourse was given a significant ranking up, ratcheting up by Cameron post 2010 election. So I know it's not the kind of response that I know it's not exactly the response to your question, but I think that there is a cultural problem, and I think the cultural problem is that, you know, the idea that somehow businesses are over-regulated specifically and over-enforced, specifically in the context of health and safety legislation. When I show, or when Dave White and I show those kinds of figures about the decline in enforcement during the 2000s, most audiences, I'm not saying I was disappointed by your response, but most audiences are generally staggered. When you say that the average workplace by 2010 in the UK, there's no such thing as the average workplace, but statistically we can talk about that. When you say the average workplace by 2010 could expect to see an inspector once every 38 years, people are staggered. Because the idea that inspectors are somehow intruding into workplaces on a regular basis has gained significant currency. So now I'm rambling on. What do you do about that? I think that one of the most powerful arguments, and I don't want to eulogise sentiment and emotion, but I think they have important roles to play. I think one of the most powerful arguments, vehicles for countering that culture, are the families groups whom I mentioned at the start of my talk, Families Against Corporate Killers, for example. These are, many of them are my friends, I respect all of them, right? So I'm not saying things about them I wouldn't say to their face. These are generally apolitical, regular people going about, they're not campaigning about health and safety until someone, their son, their husband, their brother, is killed at work. And then they realise the obstacles to justice, and then they realise that then they want to kind of campaign about the lack of enforcement. And I think that their voices are the most powerful voices we have, much more powerful than my statistics, much more powerful than other people's socio-legal arguments. So when you're faced with those real families with real tragedies, I think that they're very powerful voices which may eat into that health and safety gone mad culture.
Very interesting. Does anyone else have a question? Sir in the red sweater.
Greg Yost, Justice Canada. I wonder if you could comment on two things under that British legislation. First, what is the mens rea test for the corporation? Because that's rather important with us. And secondly, maybe I misunderstood it, but you said that was just limited to the corporations. What's the responsibility of the directors and senior officers and such under the British law, so we can compare it with Canada's?
Okay. The legal test is something called the senior management test. And essentially what that does is it takes mens rea away from any one individual and it aggregates that at a senior management level. Now, senior management hasn't been defined and hasn't really been tested by those three cases. So there is, that will be tested through the courts at some point, and there are many, many concerns about how that test will play out. But the principle of identifying the company with one or several specific senior managers or directors, the problem of the old law, has, it's claimed, been broken by this new law. I'm actually not so sure that that's the case. And in fact, if you look at the three cases, if you look in any detail at the three cases, it's very easy to identify senior managers with, specific senior managers with what the company did or didn't do, which generated the debt. But it's a senior management test which aggregates mens rea. Now, so that's the first part, that's the first question. The second part of the question is the law generates no liabilities whatsoever for individual directors. Individual directors can still be prosecuted as they could prior to this new law for gross negligence manslaughter. and they can also be prosecuted as individuals under what's called Section 37 of the Health and Safety at Work Act. The original proposals which came from the Law Commission in 1994, which were then expanded upon in 1996, did include the possibility to prosecute individual directors for manslaughter. And in the, how many years it was, 13 years that the Act came into law, there was a key point around 2002, I think it was, when that provision was removed from the law, and it was removed after consultation with 8 trade bodies, 8 industry associations, a formal consultation process with 8 industry associations. So that's a long way of saying the answer to your second question is that the British law has no impact at all on individual directors.
Any other questions? My brother, Andy King.
Thank you. Part of my question is being affected by the last part of your presentation with those extraordinary quotes from Cameron that put health and safety under attack as a problem. Because what my question was about is that the process of deregulation and reduction of enforcement by the people generally responsible for health and safety is a phenomenon in Canada as well, as it is elsewhere. And so one of my line of thinking is that with the decline of regulation enforcement of health and safety generally, there is an increase in pressure because Westrays happen, fatalities happen, to use the criminal justice system to act in the most egregious of cases. But that sort of is kind of a response to the absence of deregulation. However, in posing that question to you, I'm posing it in the context where the government itself is demonizing health and safety as a worthwhile project to provide those conditions to workers. So it may not work quite as well. So I'm trying to balance what is the explanation given for demonizing health and safety? Is it just purely gets in the way of business? And what is your sense, at least at a local level, is there support for that kind of agenda, or is there a recognition? I mean, what got the Westray Bill passed in part in Canada was public surveys of the public that showed the support for holding corporations accountable in this way.
Okay, I think there are two questions in there. I think I can probably deal with them both briefly, amazingly for me. I think that the demonising of health and safety, is it just about business? I think there was an American, a US industrial relations person called Harry Brill who made a point in a 1986 piece, which I thought was very important and which I try to hold on to. Which is that of all attempts to kind of impose regulation upon business, health and safety law is that which business most objects to, because in his words, it interferes with the minutiae of production. It attempts to intervene in the ways in which the job is organised and the job is done. So when I come up, I mean, I'm sure things are more complicated than that, right? But when I come up against the kind of question which you pose, which is an important one, I tend to bear in mind Harry Brill's very nice response to that. The second part of your question is, there is some work that's been done in the past 2 or 3 years by a British academic, a guy called Paul Armand, with whom I disagree on almost everything about, right? I have to say, and him with me as well, to be fair to him. But he writes about health, he researches health and safety. One of the things that he has been doing, though, is through focus groups and through surveys, is to attempt to chart the public mood for pro-criminalising strategies, particularly in relation to large-scale fatalities. And I think most recently a piece has just come out, or is coming out next month in the British Journal of Criminology, but so you could check that there. But Paul Armand documents fairly persuasively, I think, that there is widespread public support for holding companies to account, certainly in relation to multiple fatality incidents. And one would kind of expect that, right, because they just seem so egregious. But of course, one always has to separate that out, I think, from what's seen as the kind of mundane, pettifogging, bureaucratic, burdensome, low-level health and safety stuff, which we all really don't kind of like, do we? So I think that those two things can be going on at the same time.
We have time for a couple more questions. And Rob Champagne.
Thanks, Andrea. Robert Champagne from the Steelworkers. I'm just wondering if you know anything about the response of the British Labour movement to the failures of the legislation that you're talking about. Has there been any sort of organized response from the Labour movement to the three convictions?
There is no, in relation to the Act specifically, there is no organised response. There clearly is an attempt on the part of the Labour movement to respond to the wider context of declining enforcement and more recently formal deregulation on the part of the coalition government. But that tends to be, if I'm being honest, on the fringes of the Labour movement and organised through something called the Hazards movement, which is both part of the Labour movement, but also represents community organisations outside of that. I've worked with the Hazards over many years, not because I work with them, but they're a fantastic campaigning organisation. And much of what they do seeks to support union-appointed safety reps in workplaces and indeed roving safety reps between workplaces where specific workplaces are not organised. So there is a response, not in relation to the Act specifically, there's a response to declining enforcement and deregulation, but it's on the fringes of the Labour movement. And I have to say, I've said this in both at Labour Party conferences and also at Trade Union Congress conferences, and it doesn't make one very popular, but I have to say that in general, the response of the mainstream Labour movement in the UK, certainly trade union movement, to the kinds of things I was talking about has been pretty lamentable. Yeah, it's been notable for its absence.
So before I recognize the gentleman at the microphone, I just wanted to inviter des gens pour demander des
I
questions.
wanted to ask people, say that they would come up and ask questions in French. I'd like to say to my...
Et un confrère en français, ça serait... a sister in French would be ideal. All that being said, sorry for the intro to your question. Sir.
Bonjour.
Hello? Je vais poser la question.
Translator. Okay. Je suis
I'm Jean Otto. I'm a professor at the École de Technologie Supérieure, an engineering school. I'd been working on workplace prevention for many years, and I began with a Den Moral investigation that took be Belle Moral 32 years later. There were 8 people killed there. There was a criminal prosecution that was practically and there was and everything was foreseeable. Anyone could have seen that there was a dangerous area in that mine. So my question is much more in the area of prevention. When you spoke about the corporate culture in which occupational health and safety is opposed to productivity and economic performance, when we analyze accidents, what we see is that work-related injuries are just the tip of the iceberg. Unfortunately, once there was a worker who put his hand somewhere and his man was cut off, but the things that cause the disruptions and that means that there's economic loss for the company. So opposing one thing to another is a mistake, because when we correctly correct the causes, we also are helping the production machine to go forward. And very often they'll be talking about human error and to put all the responsibility on the workers' shoulders. But what I've seen is that workers face choices that are called work, produce, and have a salary versus setting up protection systems. And if the protection system is not adequate and interrupts the task, the worker will prefer the task because that's what provides him with his pay at the end of the day. So we're putting workers in front of horrible choices. And when we work appropriately, people use the systems, and we've realized when we analyze costs and productivity, those things are profitable. So as far as I'm concerned, when you talked about corporate culture, you reflected what we hear very often, and we work with prevention. What we see is something very different. We have to take time to do in-depth analysis. And the last element, there were people who talked about enforcement. There is a problem. There is a lack of independent experts, and because money, what you called the HEC, the research development, we have research institutes everywhere, everything, but there's not much money in that field. So research projects aren't developed, and it's very expensive. So if there's no budget, there is no expertise, and we can't have proof for the prosecutions, and that's the way it ends.
Well, let me thank you for that. Let me just say a couple of things in response to what you've had to say. The first thing is, look, I can kind of the argument that you make about it's essentially more cost productive not to kill or injure workers and not to disrupt the production process. In the UK, we would call that the business case for health and safety. So it's in the interest of the business to perform well in the context of health and safety, as indeed, a well-managed business, as indeed to manage all aspects of a business. So, now, I think that there is some, there's a couple of points I'd like to make. The first is that argument, even if it's true, ascribes a rationality to business organisations, which I don't think that they deserve, because most business organisations, and indeed the people who own and control them, are not just irrational, they're also, I'm sorry to say this, they're also pretty stupid in general, in my experience. Now, I'm being a bit flippant, but I think that to ascribe to individuals, or indeed to corporate entities, the level of rationality that argument requires, I think is problematic, although I'm not dismissing the argument at all. Well, a bit, I'm dismissing it a bit, actually. The second kind of qualification to the business case I would make is I think if one takes a perfectly rational view of the world and of economic activity, I think I would agree that it's counterproductive. Many instances of disrupted production, which may not end in any injury, dangerous occurrences, and then low-level injuries and fatalities. Many of those are counterproductive to a functioning, profit-making organisation. So I think the business case has some value, but beyond a certain point, and of course none of us will ever know where that is, I also think the case can be made, as Theo Nichols and David Armstrong made it 35 years ago in their lovely pamphlet, Safety or Profit. After a certain point, of course, it is profitable to manage dangerous workplaces. So I think the business case only takes us so far. The second point, which is the quite different point that you made, I think about lack of resources and lack of money and so on. One of the very mundane problems that we have in the UK, and it may well be the case here, is that the main regulating body, the Health and Safety Executive, is losing aside from cuts, is losing experienced personnel. And the reason it's losing experienced personnel, of course, is because it can't pay wages to compete with private industry. And private industry wants those people who are or were inspectors to act as safety consultants in their organisations. So there's a very simple kind of economic reason why experienced staff are leaving and have been leaving HSE, and I agree with you, it is about money and resources, yeah.
Alors, we have time for just one more question. So I'm going to recognize Catherine Lepel as she scuttles towards the microphone.
Just a quick question/comment, but there is a question in this. Our colleague just raised the Balmoral, and it reminded me the last time I published on the subject was 25 years ago, which was the Balmoral. And at that time, if my memory is correct, there was a jury trial. And this was a mine accident in a very small town in Quebec. And the members of the jury were the men and women who relied on the mine, which was the only industry to live. And I know, for having translated your slides, that there are issues that are raised by judges as well as to staggering the delay for paying fines because they don't want the business to close down. And finally, we know, or most of us know, what's going on with the asbestos mines and the pressure from the communities to keep those open despite everything we know about asbestos. So how do you factor in the pressure from the workers and the communities who want to keep these businesses open because it's the only survival mechanism that they've got in those communities?
Yeah. Well, that's a very good question, of course, and I'm going to give you one very concrete example in response to that. I preface everything I say, what I'm about to say, by saying, look, I'm very privileged. I do a job I like, and I earn a very nice salary, and my job's not under threat tomorrow or next week. So I preface everything I'm going to say by that. I began working with a local campaign group in north part of Liverpool about 12 years ago. It's one of the most, not just deprived areas of Liverpool, but one of the most deprived areas statistically of the country. And a chipboard plant was set up there in 1999 with a large government grant, and it provided 200 jobs for local people. Well, 200 jobs in any case. Some were locals for sure. And very quickly, a community campaign organisation was set up, which caused hostilities within the community because the community organisation claimed that they were experiencing pollution from the industrial process. In fact, chipboard manufacture produces formaldehyde, which is a carcinogen. Okay. And then became clear that there was significant problems with the way the plant was being managed in terms of health and safety. There were a whole series of fires and explosions. There were a long list of recorded injuries, and ultimately there were 3 deaths within about 6 months, which in a plant of 200 people is fairly significant. And the campaign organisation I was working with began to call for the plant to be closed. Began to call for the plant to be closed because for 5 years, for 6 years, for 7 years, and then eventually for 12 years, the management at the plant had shown no ability to manage that plant safely. And I was part of that campaign, and of course it created problems within the community and also with the local labour movement. The company eventually closed the plant in May or June of this year. It doesn't matter the details actually. And although it means that 200 people now at one of the worst economic times have lost their job, right? But I don't think, given what was going on in the company, and so in terms of people's health and safety, and also in terms of the despoilation of the environment and the possible health effects upon local community, I don't think that company and those people, I'm sorry to say this, have a right to allow that company to exist if it's going to be managed in that way, which causes a whole series of harms. I don't think, so the jobs have been taken away, which is awful, and they're probably not going to get a job in the near future where they are. But I don't think that they, that they have a moral claim on those jobs in a plant which, not through their own fault, but systematically showed itself not to be able to manage in a safe way, in a way which didn't damage the natural environment and didn't damage the health of people around that. So, it's not, health and safety is not as to sell, really. I think that's kind of what I'm saying, and that's a very harsh point to make.
So some very thought-provoking comments. So we're just going to take a short break now for 15 minutes. So I would ask that everyone be back by 10:30. And as just one other thing, if I can ask the people speaking on the next panel on corporate criminal liability to please come up to the front and settle in. That would be Barb Nace, Steve Hunt, Kenneth Jull, Céline Gigard, and Jamie Gurjak. Please, and we'll see you all back.